Good afternoon, and thank you for joining us for today's National Conference of State Legislatures webinar, New Transportation Technology, Avoiding a Patchwork. My name is Ben Hush with NCSL, and I'll be your moderator for today. This is the third webinar in NCSL's Natural Resources and Infrastructure Committee's 2019 Spring Webinar Series. The series features a total of 6 webinars, with our first 2, that are now available online, focusing on carbon capture and storage technologies, as well as traffic safety injury prevention strategies. And after today's webinar, we'll have 3 more taking a look at the future of plastics, the emerging regulatory and legislative landscape of cell-cultured meat, and finally, the policies that are shaping the future of the nation's electric grid. For a complete schedule and registration details, please visit our website, www.ncsl.org. But back to our focus today. Before I introduce our speakers, I want to review a few housekeeping items. Today's webinar is a platform for information exchange and engagement. Over the next hour, we encourage participation through our chat box, so feel free to type your questions and answer any questions you see in the chat box, which is in the lower left-hand part of your screen. We will hold a formal Q&A after both presenters are finished presenting. Our webinar today is being recorded, and registrants will be able to access a recording of the webinar and presentation slides on NCSL's website after the webinar finishes up. Additionally, you can download the presentation slides being used today by clicking on the Resources tab and the speaker bios in the Speakers tab at any time during the presentation. Now that housekeeping is out of the way, let's get back to why we're here today. 2018 featured some important milestones for unmanned aerial systems, or drones as they're commonly referred to. These milestones included, but of course are not limited to, the implementation of the Federal Aviation Administration, or FAA, Integration Pilot Program, often acronized as IPP, and of course the passage of the 2018 FAA Reauthorization Act. While drones represent a significant technological achievement, the question of how drones should be regulated is at the top of a lot of state legislators' minds. To help us fly into these topics are 2 drone experts, Scott Gore and Jason Sneed. Scott serves as a senior congressional liaison at the Federal Aviation Administration, where he works with members of Congress and their staff on a host of issues under FAA's purview, including, of course, unmanned aerial systems. Before his time at FAA, which is now approaching close to a full decade, Scott worked on Capitol Hill for former Congressman Nick Rahall. Scott has a bachelor's in political science from Arizona State and a master's of legislative affairs from George Washington University. Scott, thank you so much for joining us today, and the floor is yours.
Great. Well, thanks very much, Ben. Appreciate the introduction, and it's great to talk with all of you, NCSL and state legislatures. Just a little bit, as Ben said about my background, been at FAA for about 10 years and was on Capitol Hill before that. But one thing I really want to note for the group is that I got my start in public service actually at a state legislature working in Arizona. I worked at their state legislature for about 3.5 years, so I have a unique appreciation for the role of state legislatures, the great work that all of you do around the country, and how in the drone and UAS realm in particular, that broader integration of the technology is only going to be achieved when we all work together across all governmental entities, state, federal, and local stakeholders working collaboratively together. So regarding the FAA's Reauthorization Act from October 2018, which is, I know, the big topic of the session today, the big thing that's clear to me from the legislation is that the FAA has quite a lot of work to do from the provisions in the legislation in the drone area. It was a 5-year reauthorization for the agency, and we're only in about 7 months into it after enactment at the beginning of October last year. So I think it's important to keep that time frame in perspective regarding the bill. For the UAS provisions which there were many, which we're going to talk through, our FAA UAS Integration Office is developing implementation strategies and coordinating those strategies across the agency, and they're tracking progress on all of our deliverables and requirements. And of course, I'm supporting that effort from my role in our Government Affairs Office here at the FAA. To give you an idea of the sheer volume of provisions that we're dealing with, when the final bill was released right before enactment last fall, we took a look through the text, obviously, and we counted approximately 130 pages worth of drone-related sections that were in the reauthorization bill for the agency. 130 pages. So just to give you some sense of that scope, it's really quite a lot of work for the agency to even digest everything that was in those 130 pages, develop those detailed implementation plans that I mentioned, and execute those plans. And of course, the passage of reauthorization didn't exactly come with a big bag of money for the FAA when that was passed. Appropriations for the agency are handled on Capitol Hill through the appropriations process, as most of you know. And so that's a different process up there and separate from the reauthorization. In our current year appropriations for the agency, we did receive a modest increase for our UAS work. However, it only amounted to about a 10% increase in the agency's budget for our UAS activities. And I think in those 130 pages, as we saw all the different provisions, we can all agree that there was a lot more increase in workload for the FAA than 10%. There was a lot more put on the agency and a lot more required than a 10% increase in work. And the other challenge for us, despite the bill having a 5-year duration, a lot of the deadlines that Congress imposed on us were within the first year and a half or so of the enactment of the legislation. So it was very much front-loaded with deadlines, and that was a bit of a challenge to work through. Most of the provisions are going to become part of the, I should say, implementation of the provisions that Congress put in place. Implementation is going to become, in many cases, part of the ongoing work of the agency, to our ongoing programs, our ongoing efforts in the UAS realm, rather than managed as standalone new projects. The easiest way we can integrate the new requirements is to bring them into our existing work and our existing projects wherever possible. And despite the volume of the provisions that we're facing, the reauthorization really was seen as quite a positive development for the agency and for UAS integration broadly. There were a number of very helpful items in the Reauthorization Act that help advance our collective goal across all the stakeholders, our collective goal of advancing safe and secure integration of UAS into the airspace. The bill reinforced a lot of the programs that we already had existing, such as our integration pilot program, which we'll come back to that in a minute if you're not familiar, and our UTM pilot program, UAS, which is UAS traffic management pilot program that we have ongoing as well. Some of the other provisions that were particularly helpful to the FAA had to do with restoring the agency's regulatory authority over recreational and hobbyist users of unmanned aircraft. That was a very helpful section that will provide good efforts going forward in terms of integration, and we'll talk more about that in a minute. There was a section on ensuring the drones are integrated in a secure fashion. Our security partners at the federal level have been very interested and a little bit concerned about the proliferation of drones, and so the legislation gave the Federal Department of Homeland Security and the Department of Justice new authorities for counter UAS activities and testing, so that they can address any nefarious uses of the technology. And even though that's obviously not the FAA's primary role, we're more focused on the integration side. However, the new counter UAS authorities for the other federal partners do help us with our rulemaking efforts, because we're all kind of part of the federal executive branch, and our rulemaking efforts do go through those other agencies for review. So those other new authorities to ensure we have secure integration are very important to the FAA. Let's see. In terms of sections that we are actively working, and some of our FAA's early accomplishments under the Reauth directives, one of the good items that I like to point out had to do with the safety justifications for waivers. This was section 352 from the Reauth, and a directive that the FAA posts online are an example of safety justifications for different waivers that have been submitted by industry. And so those were posted a few months ago, and those can be found on our FAA website, www.faa.gov/UAS. The section right after that in the bill, 353, had to do with how you can get approval from the FAA to fly a drone under an emergency basis after like a natural disaster or other emergency, if you need emergency approval from the FAA to fly in a controlled airspace area or in a temporary flight restriction, how can users that are connected to responding to that natural disaster, it could be a hurricane, it could be an earthquake, a tornado, whatever, how can you get emergency approval from the FAA? So when we saw the reauth interest in that, we posted a new page on our website giving specific guidance to users on how they can contact our air traffic folks at FAA to get emergency approval, which oftentimes can happen within under an hour to get approval. And we can provide that link I can provide that link to Ben for anyone that is interested to see the new guidance that we posted on that issue regarding emergency approvals. I mentioned recreational drones a minute ago. That was section 349 from reauthorization. And Congress put in place new requirements for these kind of recreational users of drone technology, and they repealed the old requirements for recreational and hobbyist users. Those old requirements had been in place for about 7 years since our 2012 reauthorization, and now Congress put in place new requirements. Just last week, the FAA put out a Federal Register notice with some of our initial implementation steps for these new requirements. And I do want to highlight just this section alone, 349, there's a lot of work for the agency under this section in order to implement it. It is quite a tasking involving a number of different offices across the agency because there's a lot of new requirements, and both placed on drone users as well as the FAA in terms of granting airspace authorizations and a knowledge test that we're developing and recognizing community-based organizations. There's just a whole lot packed in one section of the reauthorization. So we're working hard on that one. And then the one other section I wanted to highlight for the group, there was a section, as I mentioned, that codified or that reinforced the FAA's existing integration pilot program that's underway with a number of state, local, and tribal governments around the country. If you're not familiar with the program at the state level, we're working with the Departments of Transportation in the states of Kansas, North Dakota, and North Carolina. And we're also engaged with a number of local partners in 6 other states across the country. The goals of this UAS integration pilot program, what we're really trying to drive at under the program is strike the right balance between federal, state, local interests in drone activity, which I know is a key issue and a key area for all of you. So we're trying to strike that right balance between the different interests, as well as accelerate the approval of complex drone operations that currently require special permission in the airspace, advanced operations and complex operations that currently require a case-by-case approval to ensure safety is protected. So the FAA understands that we need to work together, all of us, to integrate drones into the airspace, and the pilot programs are helping us do that, helping us find the right balance and the right ways to communicate across governmental entities and across governmental lines. And we're eager to see the results of those pilot programs, which we're right in the middle of. The program has about 18 months left before it's scheduled to conclude in about fall of 2020. So that's just a little bit on our integration pilot program. And then I wanted to also touch on for the group, just to give a high-level update on the FAA's rulemaking efforts when it comes to unmanned aircraft. We are making progress on quite a number of fronts and have a lot of activity going on related to rulemaking for unmanned aircraft systems. Back in February of 2019, so it was just a couple months ago, we published 3 regulatory updates, 3 different ones related to drones. So that was a big milestone for the agency. We posted a proposed rule on the operation of drones over people, and we put that out for public comment to get feedback from the community, feedback from stakeholders and the public. So that was the first one. The second one was an advance notice, or just kind of teeing up a lot of questions. We call it an advance notice of proposed rulemaking that did not have regulatory text, but asked some key questions related to the safe and secure integration of and operation of UAS. Some key questions that are that our security stakeholders had asked the FAA and want to get clarity on. So the advance notice of proposed rulemaking on security had some of those key questions that we wanted to get feedback on. So we put those questions out for comments as well. And then the third item that we posted in February was an interim final rule with a small change related to how you mark your registration number on an unmanned aircraft, on a drone. Prior to this change that we posted in February, a drone operator, drone owner could put their registration number inside a battery compartment. And there were some security concerns that were brought to FAA's attention from some of our partners, both Department of Defense and our other federal partners, who really wanted the registration number to be visible on the outside of an aircraft, so that law enforcement or security personnel did not have to open the device in order to find the registration number. So we made a small change to how you mark the aircraft to require that the registration number be placed on the outside of the drone. On the proposed rule for operation over people and the questions, the security questions, which was the advance notice, the comment period for both of those closed in mid-April, and the FAA is in the process of reviewing and evaluating the comments to those. So those are some of the key regulatory items that we have recently made a lot of progress on. And then another key area that the FAA is working on right now that is a big focus for the agency is remote identification of drones, which you may have heard about that, talked about before. This rulemaking is one of the agency's highest regulatory priorities, and it is critical to further the integration and further expand the integration of UAS systems into the national airspace. Before we can finalize the rules that we recently put out for comment, we really need to get remote ID in place and finalized to meet the needs of our security partners and meet the needs of our law enforcement partners as well. So we're working very hard on remote ID, which is a complex and very technical rulemaking project. And the Reauthorization Act that restored the agency's authority over the recreational side was really a precursor, a critical and necessary precursor to developing that rule, the remote ID rule, in a way that would meet the needs. Our current schedule for publishing the proposed rule for remote ID, we expect, at the present time, we expect it will publish in approximately September 2019, so a little bit later this year. And we're looking forward to getting the feedback on that after we publish it. Beyond that rulemaking project that's underway, the FAA is working on a proposed rule that relates to flight restrictions near critical infrastructure facilities. That was another congressional directive that the agency has from a couple years ago, and so we're working on that proposed rule as well, which will likely be a little bit behind the remote ID rule, and then a little bit further on the horizon for our rulemaking program would be rules for drones that relate to beyond line of sight flights, so beyond where the pilot can see the drones, can see the aircraft from his position on the ground. So the general rules for beyond line of sight flights, so those in the future won't require a case-by-case approval. There will be just a general rule that users can follow. So that's on the little bit longer term horizon that we're getting data from the integration pilot programs in order to support that rulemaking effort. And then also a future rulemaking on carriage of property, so for package delivery and things like that, that a number of companies are interested in doing in the future. That we'll be working on those kind of general rules for carriage of property. So those are the main highlights from me on reauthorization implementation and where things stand from the FAA's perspective, and a little bit about our rulemaking program and the integration pilot program, which is really a key focus area that we're engaged with stakeholders from across the different organizations at different states as our partners in that program. So that's it for me. I think I'm going to turn it back over to Ben.
Great, thank you so much. And as folks can see, Scott's contact information is up on the screen now, so if you have any questions that you just want to ask him, over email, you can do that at his email. I will just tell you from experience, he is great to work with and extremely responsive. So Scott, thank you for that presentation. I got a couple questions from folks, but if you don't mind, I'm going to save them until we kind of get into the more formal Q&A. And just a reminder, if folks do have questions, please use the chat box in the lower left-hand portion of your screen. We will try to get to all of them. I think we should have enough time to get to all of them. But next up, we have Jason Sneed. We're going to kind of shift the focus a little bit. I mentioned at the top, obviously drones are a very exciting new technology, but there are a number of questions as to how you really incorporate such a new technology into our existing legal structure. And so Jason's going to talk a little bit about that. Jason currently serves as a senior policy analyst at the Heritage Foundation, and obviously in addition to his work on drones, he focuses on reforming the nation's civil asset forfeiture laws, the sharing economy, and criminal justice reform and policing. He joined Heritage in 2009 as a staff assistant to former U.S. Secretary of Labor and current U.S. Secretary of Transportation Elaine Chao. He holds a master's degree in public policy from George Mason University and a bachelor's in political science from Bowling Green State University. So Jason, thank you so much for joining us, and the floor is yours.
Well, thanks, Ben, and thanks to NCSL for inviting me on to talk about what is really an important emerging area of law and policy, which is how to deal with drones in low-altitude airspace, near people, near property, within communities. As we just heard, there's quite a lot of exciting developments in this space, and there really is a tremendous potential for drones to be revolutionary and life-saving. And really, it's difficult to predict exactly how exciting this technology is going to be because it's so new. But nevertheless, there are going to be some legal complications, as there always are, and questions and conflicts are going to emerge, particularly in this case, between drone operators and property owners over where and how frequently, for instance, drones can operate over private property. And so I wanted to take the opportunity to talk a little bit about existing airspace law and property law, and a direction that I think would be good for states to consider as they contemplate how to move forward in the UAS space. But in order to do that, I wanted to back us up a little bit and talk about the development of airspace property law over the last several centuries. And I'll try to keep this brief and cram a couple of centuries of law into about 10 or 15 minutes. Just to go back to airspace before the dawn of aviation, the prevailing and common theory of airspace ownership was what was known as the ad coelum doctrine. And as you can see from my somewhat crude illustration on the screen here, that doctrine simply said that if you are a landowner, you own not just the physical land itself, but a column of airspace extending above that land, essentially without limit. It would go all the way up to the heavens. It conferred on property owners a right to exclude objects from that airspace, essentially no different from the right to exclude an object if it was on the land. So if someone was traipsing across your backyard or flying a kite over your yard, the trespass was essentially the same. And aerial intrusions of all sorts, if you look back at property law, were treated that way. So overhanging structures, tree limbs, if someone happened to have a cannon and fire a projectile over, those were all considered trespass. But the ad coelum doctrine came to an end because of the event that you see here, the advent of aviation. When the Wright brothers invented the airplane in 1903, that launched a revolution that changed the nature of how airspace was used. It became a much less static environment where really the only things that moved through it were blimps or balloons, and there became a need for aircraft carrying people or cargo to be able to transit across routes that very quickly, actually, from the dawn of aviation, would require them to fly across many hundreds, thousands, or tens of thousands of private plots of land. And that brought up a question: if you can trespass in airspace regardless of altitude, so a trespass at 5 feet is the same as a trespass at 30,000 feet, how are nascent airlines to develop? How are pilots to deal with the legal liability that could come from essentially endless trespasses every time you happen to fly over? And so Congress in 1926 enacted the Air Commerce Act, which created the concept of a navigable airspace above what was then defined as the minimum safe altitudes of flight. Today, it's defined somewhat differently, but above that altitude, the airspace became essentially a federal commons, an aerial highway that people had a right to access and a right to transit. It became a domain for aviation, and we've all seen the benefits of that over the last century. Below that, though, there remained an interest that private properties owned some degree of airspace, but the question was to what extent that property ownership continued to be in force. And in 1946, there was a Supreme Court case, United States v. Cosby, that considered the question of aerial property rights. In that case, just by way of a very brief background, there was a chicken farmer, Cosby, who had a farm that was very near to a small regional airport that was taken over by the U.S. government during World War II. So there were frequent military aircraft, including bombers, that would fly over the property at very low altitudes at all hours of the day and night, and it quite literally scared Cosby's chickens to death. And so Cosby brought a takings case against the government, asserting that the government had, because of these overflights, taken property and essentially abrogated its usefulness because it had substantially interfered with the use of the property. So the Cosby Court, first of all, when it considered the facts of the case, affirmed that that old ad coelum doctrine that I talked about had no place in the modern world, but nevertheless concluded that property owners still possessed a property interest in what it termed the quote-unquote immediate reaches. As the court said, and as common sense tells us, if the land itself is going to have any value, you have to be able to do something with it. So you have to be able to erect structures, whether that's a house or a farmhouse or any other physical structure. You have to be able to use some amount of the airspace above the land. And so if the landowner is to have full enjoyment of the land, they must have exclusive control of some stratum of airspace close to the ground. And further, the court said, quote, invasions of the immediate reaches of the airspace are in the same category as invasions of the surface. So what the court essentially said was that for purposes of their legal analysis in the case, they were going to treat low altitude airspace as essentially the same as land would be in a property dispute. But then the question became, what exactly are the immediate reaches, and that was left unresolved by the court. So now we can take a look very quickly at the concept of aerial trespass that emerged in the decades after the Cosby decision as manned aviation continued to expand and proliferate in U.S. airspace. And if you look at, for instance, the second restatement of torts, it defines aerial trespass as essentially a two-element trespass, where if you're talking about trespass to land, all you have to do is violate the property at its basic understanding. No harm has to be showed. That simple violation gives you, as the property owner, the right to exclude an unwanted intruder. Here, there became essentially a two-element test. First, a property owner has to show that a flight of a manned aircraft occurred in the immediate reaches, to use the terminology that was applied in Cosby. And then secondly, that flight had to cause some substantial interference with the use and enjoyment of the land. So you can see a lot of that terminology from the Cosby case is essentially being cross-applied here to what the Restatement of Torts labels as an aerial trespass. Now, these are quite nebulous standards, and actually the showing of harm is something which has been pulled out of nuisance law. But despite the fact that it's an ill-defined standard of exactly how high the property interest is, how high do the immediate reaches go, we don't have a figure for that. It worked reasonably well over the last half century or so for manned aviation for a couple of reasons. There are, first of all, outside of the airspace surrounding airports, relatively few aircraft operating in the low altitude airspace. And part of the reason for this is that federal aviation regulations generally require that aircraft remain above the navigable airspace threshold for safety reasons. So there just aren't that many opportunities for property owners to have an actual genuine trespass conflict with a manned aircraft, and that is part of the reason why this nebulous standard has been so successful over the last several decades. But the question becomes, will this same standard work for drones? And in order to evaluate that, I think that we have to consider a few interesting variables that distinguish drones from manned aircraft. The first being that drones outnumber today manned aircraft by several orders of magnitude. In fact, just recently the FAA had to revise upwards its prediction of how many commercial and recreational drones there will be in the U.S. airspace over the next 5 years, to an estimate of about 835,000 commercial drones and more than 1 million recreational drones by 2023. Another factor to consider is that drones are physically different from traditional aircraft. So where we're talking about large aircraft, typically with multiple engines in many cases. For manned aircraft, we're talking about things which are much smaller, although they can be quite large when you're talking about drones. And that weighs into the question of how easy it is for a landowner, for example, to demonstrate that an overflight is causing substantial interference. Obviously, the amount of noise and the potential nuisance value of a small DJI Phantom is going to be different from an Air Force bomber, for instance. And the third factor is that drones are going to be flying in low-altitude airspace considerably more often than manned aircraft do. If you look to FAA regulations, where, as I said before, those regulations generally require that aircraft maintain a certain altitude above the ground, for drones they actually apply the inverse standard, and for safety reasons hold drones out of the navigable airspace and close to the ground. Also, if you look at what sort of operations we're tasking drones with, there are also sort of operations that are going to require that drones frequently be in low-altitude airspace, just a few feet above the ground. If you're talking about package delivery, if you're talking about infrastructure inspection, if you're talking about law enforcement applications, we're not talking about drones that are going to essentially take off and then fly several thousand feet in the air and then only land again when they get to their destination. We're talking about drones that will be frequently going up and down in low-altitude airspace, where there are people, where there is a number of physical structures, and where people generally perceive that they have a property interest in being able to keep trespassers out. And so given the fact that conflicts are inevitable in this space, and in fact are already emerging between property owners who think that they ought to have a right to exclude drones from flying at very low altitudes over their property, and drone operators who often assert the contrary position, that they have a right to fly in the airspace above that land, the question becomes, will the aerial trespass standard work for drones? And I do not believe that it will, for a number of factors. The first is that the existing aerial trespass standard is a nebulous, nuisance-like standard that will inevitably be inefficient if it has to bring all of the conflicts which we anticipate seeing in the future to court to resolve. Asking, for instance, whether a trespass took place in the immediate reaches without having some sort of a figure for what the immediate reaches are, asking what constitutes substantial interference, is going to be a fact-intensive, costly, lengthy, and burdensome process that's going to impose burdens on courts, on property owners, and on drone operators. Further, it risks leading to inconsistent standards applied on essentially a property-by-property basis. We often hear members of Congress, regulators at the FAA, and members of the drone industry concerned about a regulatory patchwork developing, but this type of regulatory patchwork would be a much granular one, where different standards could be applied depending upon the particular facts of a specific drone overflight on a property-by-property basis. That would be very difficult to navigate if you're a drone operator, and it'd be very difficult to predict if you're a property owner seeking to try to deal with an overflight that you don't want. And so that unpredictability, I think, is going to really hold back the development of the drone industry and lead to actually more conflicts between communities and property owners and drone operators, because they don't have any sense of clarity about what exactly the rights of the relative parties are. I think that a better approach would be to clearly define the property rights boundaries in what are the immediate reaches of the airspace. So the lateral boundaries have never been in question, but I think that a good way to go about simplifying and clarifying this process is to provide a ceiling for a property right boundary, something that would be, I think, reasonably close to the ground and reasonably far away from the navigable airspace, so that drones have airspace that they can transit, and so that drones are not pushed up in any way to where they might cause problems with manned aviation, but nevertheless could provide a degree of protection for property owners who may not want to have drones transiting just a few feet above their backyards. As the saying goes, good fences make good neighbors, and providing such a standard, which could be applied evenly across the country, would make for clear, predictable boundaries, and that would allow for conflicts that emerge to be resolved hopefully outside of the courts altogether, simply by a property owner being able to state with certainty that he can tell a drone owner that the drone has to stop flying over his property, and then that can be the end of it. And if it does proceed to a court proceeding, then the burden that is placed on the court is considerably simpler, and the litigation itself will be considerably less expensive and less difficult to process. I think that for several reasons, this type of an approach fits much better with existing trespass law and with how the Cosby Court dealt with the concept of aerial property rights. Cosby treated the low-altitude airspace as essentially land for the purposes of its analysis, and I think that doing so here for the purposes of unmanned aircraft is an important step in the right direction. And further, it fits actually within the existing understanding of trespass to land if you look at the restatement of torts, where it today is considered a trespass if you throw, propel, or place something on the land, even if that thing doesn't actually touch the land, and even if you, as the individual, never actually set foot on someone else's land. And further, firing projectiles, flying advertising kites or balloons through the air above are also considered to be trespasses to land. I think it makes much more sense to fit drones into that existing understanding of trespass law rather than go through a somewhat nebulous and difficult court proceeding trying to prove what essentially amounts to a nuisance when we're talking about trespass. And now I wanted to talk just really briefly about a current matter before the Uniform Law Commission, which has commissioned a drone torts committee to draft model legislation. I've been able to serve on this committee as an observer, and I think that it's been a fantastic experience. I think the debate has been lively, at times spirited, and all of the members of the committee have endeavored to produce the best work that they can. But nevertheless, I have to disagree with the approach that they have taken in terms of defining property rights and aerial trespass for small unmanned aircraft in particular. It's somewhat difficult to see on this page, and I apologize for that, but the proposal that the Uniform Law Commission is going to consider is essentially a derivation of the existing aerial trespass standard. And so it will require property owners to prove that not only that a drone flew over their property, but also that it substantially interfered with the use and enjoyment of their land. And in order to prove that, the proposed legislation would essentially require courts to consider 13 factors. So it's a 13-factor balancing test that would determine whether or not the drone had a right to be there, whether or not the drone substantially interfered. Now, this approach does not provide any clarity or any certainty for any parties operating drones in the low-altitude airspace or any property owners who expect to be able to have either a sense of privacy or simply to avoid the nuisance of drones flying over or the physical harm that could come from a drone flying around only a few feet above the ground. As I said, it requires property owners to prove substantial interference, which will be a very difficult thing to do, particularly at the outset when there aren't any clearly established jurisprudential standards. So courts will be applying wildly different theories, most likely, depending upon the particular facts of the case, depending upon the jurisdiction. So you risk getting a patchwork develop, and that could have a really serious chilling effect on the willingness of property owners to assert their property rights. But it could also have, by the same token, a chilling effect on individual or small business drone operators. Because, of course, if you are a large multinational firm considering nationwide package delivery service, for instance, you can probably expect to weather some degree of litigation. But because there's no clarity under this approach provided to drone operators as to what constitutes a low-altitude property interest and where they may or may not face litigation, essentially every time they take off and fly a drone over someone else's property, they could face a lawsuit. And so if you're an individual hobbyist or if you're a small business considering a local delivery service or any other use of a drone, then I think that the fact that you could at any moment essentially be slapped with a lawsuit from a property owner because you thought you had a right to fly over their property, but they disagree with you, and the only way to resolve this conflict is to go to the courts, I think that could have a chilling effect on a number of small businesses that might be contemplating this technology, on hobbyists who might be wanting to enjoy this technology. And so I think that for a host of reasons, states have an opportunity now to really set the stage for the next century or more of drone aviation by getting the balance right between the interests of property owners who ought to have a right to exclude drones in low-altitude airspace and drone operators who want to bring services to communities all across the country. Both groups need clarity in the law, and this is an opportunity to do that. And I think that getting that balance right will set the stage for all of the tremendous advances that we hope to see in the drone industry in the years to come. And with that, I'll turn it back over to you, Ben.
Thank you so much, Jason. One area I wanted to quickly follow up on was this ULC model bill you mentioned. And my understanding is the current version kind of differs pretty markedly from maybe what I'll say is I don't want to say the first version, but I'll just say earlier versions that was more kind of in line with I guess a vision that you might have been more favorable to. And I guess I guess the question is kind of why the change, if you are aware.
Certainly. So there was an earlier version of this draft bill that would have set a 200-foot threshold that would have provided the clarity that I was advocating for just a moment ago. But part of the reason that the committee decided to move in a different direction over the last year was because of an insistence on the part of, we'll call them the drone industry, if you will, but some of the bigger names in this community, that standard would be unworkable for a variety of different reasons. And I simply have to disagree with that assessment. As I said, I think that the real problem with the approach that the committee has taken is that it sets the stage for, first of all, a patchwork, a very granular patchwork that will be very difficult, particularly for drone operators to navigate, but will also chill property owners who may not want to face off in court against a big drone company. And secondly, I think that this approach really pivots from trying to seek a reasonable balance between two parties and swings the pendulum a little bit too far in the favor of drone operators, and particularly larger drone operators who, as I said, have the budgets and have the wherewithal to be able to weather litigation. And I don't think that this is the right approach for those reasons.
Great, thank you so much. So I kind of want to turn things over to kind of the last portion here, the Q&A. So again, for members of the audience, feel free to send me your questions in the chat box, which is in the lower left-hand screen. Scott, if you're still with us, I actually got some questions during your presentation that I wanted to follow up on. And the first one I just wanted to follow up on was actually one of the topics you mentioned, and that was, I guess, a forthcoming rule regarding operations in and around critical infrastructure. The question really was, it was specific to a single state, and I don't want to single out that state because I think it applies more broadly, but obviously, and you may or may not be aware, there are a number of states that have laws that have their own restrictions on operating drones in and around critical infrastructure. And so how might kind of FAA's maybe forthcoming proposal eventually a final rule, work with existing state laws, supersede existing state laws. So I guess that's kind of I'm trying to reword the question to make it a bit broader than a single state.
Yeah, thanks, Ben. Agreed. We'll have to, as we go down this path, this was generally known as the Section 2209 project. That was the section number from the original directive from Congress to establish a process, basically, where critical infrastructure facilities and other fixed-site facilities could apply to the FAA to receive a protected area, area around their facility that would be protected from drone flights. And so as we work through that process, we'll have to assess how those restrictions could interplay with any state or local requirements, as well as a number of other factors, and that's why it has to be a rulemaking project and is a really complex endeavor for the FAA. We have to look at, for example, existing controlled airspace. So right now, a lot of critical infrastructure facilities are located in areas that would already be required for a drone operator to obtain FAA approval to fly in that area. So one of the open questions is we need to evaluate how are we going to address controlled airspace? Are we going to layer a new airspace restriction or a new airspace level on top of existing controlled airspace? And how are we going to do this in an efficient, scalable way that just does not completely inundate the FAA and have to review these on a case-by-case basis, which may be thousands or tens of thousands for every sector of different critical infrastructure facility there might be. So we're going to have to evaluate all of those factors as we go forward.
Great, thank you. Totally, I think that makes sense. I guess, and Scott, maybe to stay with you for a second. You mentioned the IPP program. Obviously there are, I believe, 3 state DOTs that are working with FAA. I know you've gotten this question in the past at some other events I've been at, but kind of got it here too. Is FAA planning for, anticipating a second round? Obviously there are a number of states that have drone laws, I guess, or laws that deal with operations of unmanned aerial systems. And so is that something that FAA is considering, or is that maybe a bit further down the road once kind of this first round is completed and the FAA is able to kind of learn some lessons?
Yeah. So to my knowledge, this is Scott again. To my knowledge, I don't think there's any current effort underway to initiate a second round of integration pilot program applicants. But that's not to say FAA is unwilling or can't work with states and localities across the country and under our current rules, there's a lot of things that can take place under the general rules under Part 107, and for more complex operations, waivers can be obtained to fly those missions and fly those types of operations today with the appropriate approval and safety mitigations in place. And so FAA is certainly willing to work with states across the country on those. But in terms of that specific pilot program, I think we're focusing on the current round that we had ongoing right now. And there was actually a little bit of limitation language to that effect in terms of opening a new round from our appropriations committees when they passed our fiscal year 2019 appropriations. They'd actually put language in directing that FAA provide the appropriations staff and the appropriations committee on Capitol Hill some background on the cost of the program, and they, I think, asked us to prioritize some other drone-related activities and other congressional mandates before the agency would initiate another round of applicants or another round of partners in the integration pilot program. But it's not to say we, again, can't look at that in the future and work to accommodate any needs and requests from the states across the country.
Great, thank you. Jason, so I don't think this will surprise you that this question comes from Utah, and I guess maybe to slightly reword it, it's not really a secret that Senator Mike Lee has been fairly involved with drone issues in the United States Senate. He was a co-sponsor of the Drone Federalism Act on the previous Congress, and it's no secret that he's working potentially on another bill, not exactly the same, but similar. So I guess the question was curious as to where the Heritage Foundation might be on those.
I'll preface this by saying that as a 501c3, the Heritage Foundation doesn't take positions on particular pieces of legislation. We don't advocate for passage of a particular bill. We tend to talk about issues and policies, and I'll say that I'm certainly supportive of the notion of drone federalism. I do think that there needs to be a cooperative federalism approach taken in terms of unmanned aircraft operations. I sometimes analogize this to traffic laws, for instance, in terms of what this would look like in an ideal situation. If you think about the way that vehicle manufacturing standards are set by the federal government, safety standards are set by the federal government, but then when you get into the car and start driving it, you're complying with a series of state and local laws that tell you, for instance, how fast you can drive, where you can and cannot park, that sort of a thing. Where there are stop signs, you have to stop. All of that is set at a much lower level than the federal government. And so when we're talking about low altitude space, and I want to make sure that I'm cabining this by saying that there would be a ceiling of it's debated 100 or 200 feet, for instance, where this would be the case, that local governments would be best able to establish responsive and robust time, manner, and place restrictions is what we call them. So if, for instance, a community did not want drone deliveries after 9 p.m., or if there was going to be a high school football game, or a farmer's market, or a local parade, and didn't want drones for safety reasons to be flying over those particular events at a particular time, that those sorts of restrictions could easily be put in place at the local level, and that the localities would be best suited to be doing that. I don't think that the FAA would want to be tackling the tens of thousands of distinct jurisdictions all asking for particular flight restrictions all the time. I think that would get to be a morass. And so I am generally in favor of federalism. I do think it can function quite easily, particularly when you look at technology like unmanned traffic management systems that are going to be coming online over the next few years. I think that's the right direction to go. And I think that's also very much in keeping with my earlier comments about airspace property rights. I think these two regimes, if you will, would work well hand in hand.
Great, thank you. So with that, I would like to extend a final thank you to our presenters, Scott and Jason. We really appreciate the expertise that you were able to provide. And of course, thanks to all our attendees for participating in today's webinar. As a reminder, a recording of today's webinar and the presentation slides will be made available shortly. Our next webinar, which will be in 2 weeks, will explore the future of plastic from production to disposal. To register or find out more information, please visit ncsl.org or send my colleague, Kristen Hildreth, contact information listed on that slide and email. Thank you for your continued interest and support of NCSL, and have a great day. Thanks. Bye-bye.